Go ahead.
Well, good afternoon, everybody. I hope that everybody's comfortable, and I want to thank everybody for making time to participate in this webinar between Party McLaws and the Compass Collective. Today's topic, as you can see from the PowerPoint title page on your screen, legal tools available to creditors and borrowers during COVID-19. Before we get the substantive part of the presentation underway, I'll just introduce myself a little bit. I'm a graduate of the University of Alberta Law School, class of 1983. I'm honored to have as my classmates two of the more prominent insolvency justices in the Court of Queen's Bench. In Edmonton, Juliana Topolniski, and in Calgary, Christine Edsvik. Our class had the dubious distinction of graduating into the teeth of the impact of the National Energy Program, which those of you who are old enough to remember will recall was a program instituted by the previous Trudeau administration, which artificially pegged the price of Western Canadian oil at an artificial level that did not assist the economic prosperity of this province. The program was introduced in February of 1982, which was right around the time when articling students who were graduating the following year had to go for interviews to get, hopefully, articling positions. Many people did get positions, but by the time they graduated in the spring of 1983, many firms had fallen on hard times and their articling offers were revoked. In any event, the economic landscape into which my class graduated meant that most of my first year, my articling year, was spent doing creditor-debtor law. Those were the days in which mortgage foreclosures occupied 2 or 3 master's chambers in each of Edmonton and Calgary, 5 days a week, with anywhere 20 to 30 applications per chambers per day. So the devastation to personal financial well-being in this province was remarkable, probably unprecedented until we hit the recession of 2008, 2009. And here we are now in yet another remarkable situation, certainly as it affects the resource-based industry of Alberta. We have to do with the COVID-19 pandemic and the resulting shutdown of the economy at a time when there was a price war going on between Saudi Arabia and Russia, which conspired to drive the price of oil into the basement, to the point where traders were actually paying people to take oil off their hands because the storage facilities were full. So we are in difficult times, and the impact of the COVID-19 pandemic on the legal landscape is what I want to address in this afternoon's presentation. Next slide, please. So here's what the problem is in a nutshell. Revenues have collapsed just about across the board, unless you're in an industry which has a business plan that emphasizes online retailing, and your supply of product that you're selling online is uninterrupted. I'm aware, for example, of some local businesses that are in the hospitality industry, in the coffee supply business, for example, where not only have their revenues maintained the same, but their profit picture has improved, because as the pandemic bit, they quickly downsized by getting rid of all of their hourly staff, which is unfortunate for the staff. They put all the management people on the front lines, and their online order book just exploded. But unless you're in one of those happy industries, many people have experienced a revenue collapse and have been unable to reduce expenses correspondingly. There are 3 main items of expense in any business operation. The 3 Ps: premises, which means basically rent and occupancy costs; the product, which is the cost of the goods that the business is actually trying to sell to the customer; and finally, people, and that's wages and benefits. So with those are the three main topics, or the three main areas of expense, and the federal government has jumped into the rescue. So the solution, which is something which I know Albertans love to hear, I'm from the government and I'm here to help. Those of you who have been trying to work from home but can't resist watching the daily chat from the cottage, as some people have called it, from our Prime Minister, will know that the federal government has been introducing a vast number of assistance programs. I'm not going to concentrate on any of the programs in particular, but for those who are listening and who have need of accessing some government money, there are, as you can see on this screen, 4 programs that have been announced that are targeted at businesses. The Canada Emergency Business Account, that was the one of the first ones that was made available, and it's the $40,000 forgivable loan that's made available to small businesses, depending on the criteria, depend upon your size of your payroll. The next one, the Business Credit Availability Program, that's a relatively new one. It's for small and medium-sized businesses, and it's supposed to help with financing through Business Development Bank of Canada and through the Export Development Bank. Then there is the Large Employer Emergency Financing Facility, which was announced earlier this week. That was the program which apparently the oil patch has been anxiously awaiting, although it does have a few hooks in it, in that there has to be a climate compliance component. The fourth one on this page, Canada Emergency Commercial Rent Assistance. That's something that I know is near and dear to some of the small businesses out there. Just by way of anecdote, every now and then my family frequents a bagel shop in a strip mall that's not far from our house. And every now and then the bagel maker behind the counter bemoans the fact that he has not been able to persuade his landlord to adjust his rent, even though this particular business has had its revenues drop off a cliff. Most of this fellow's business was in wholesaling bagels to a restaurant chain, which, of course, because of the lockdown, has closed its doors, and it's not really even offering takeout. So he's got no revenue other than what schmucks like me, who go in every week or two for a dozen bagels, pay him. And believe me, that's not enough to keep the lights on. So this fellow was anxiously awaiting something by way of relief that he and his landlord could share. And the highlights of that commercial rent assistance program, as many of you probably know, is that a landlord will receive 75% of the rent, 25% from the tenant, 50% split between the federal and provincial levels of government, and the landlord has to absorb the other 25% himself. So no idea what the take-up is on that, no idea what the take-up is on anything other than the individual assistance plans. And as I mentioned, they seem to be coming out every day. The next slide demonstrates what the latest announcement was when I put this together, which was last night, yesterday being May 13th. And yesterday, the feds announced the Regional Relief Recovery Fund, making just under $1 billion available, of which $304 million will go to Western Canada, targeted at businesses who don't fit into any of the other categories, and that would be the programs that I showed you on the previous slide. The delivery mechanism for this program is the Western Economic Diversification Fund and its partners. No idea what the particulars are of that. It's new, as it was announced yesterday. And then this morning, just to show how frequently these programs are announced, I don't know if any of you were watching the CBC, but the Prime Minister announced a program for fishers. I might have thought it would apply to fishermen, but I guess that's contrary to the gender balance attitude of this government. So although it says fishers, it's actually for people who fish, as opposed to the relative of the otter that go and eat birds' nests. So fishers are meant to be getting approximately $407 million to tide them over while they're unable to work or unable to sell their catch. There was another program announced today, but it wasn't focused on Alberta or even Western Canada. It was a chronic pain fund, or I should say a chronic pain center of excellence that's going to be established at McMaster University in Hamilton, targeted at veterans of the Canadian Armed Forces. So the government is continuing to throw money out the door at a frantic pace. The consequence of all of this is going to be immense when it comes to our balance sheet. The Parliamentary Budget Office estimates that this year's deficit is going to be $252 billion, and that is about 5 times greater than the deficit that was incurred when we had to deal with the financial crisis in 2008-2009, leading to a projection by the PBO that our national accumulated debt by the end of this fiscal year will be in the neighborhood of $1 trillion. And many of you may have seen the Finance Minister, Bill Morneau, announcing in response to a question, I think it was yesterday afternoon, that the government isn't really considering whether or not it has to raise taxes here, leaving open the question of exactly who is going to pay for this and how. In any event, all of that's by way of background to kind of introduce the situation. If you have a problem, if you're a business that has a problem with meeting expenses, hopefully you may be able to fit into one or more of these federal government programs. In addition, the province has also implemented some programs. They are, in comparison to the feds, relatively small potatoes, and they mostly consist of deferrals as opposed to making credit available. I say mostly because it's a bit of a mixed bag, and I've just put in some of the highlights here. Some small and medium-sized businesses will have 50% of their WCB premiums for the next 3 months paid for by the government. Others will have their WCB premiums deferred. There's a number of different governmental charges that are going to be deferred for anywhere from 3 to 6 months. And individuals can also look forward to having a deferral of their utility bill payments to June the 18th. So recognizing that the Alberta balance sheet is certainly wasn't in good shape, I believe the estimate is that we're going to start seeing a $20 billion deficit this year. This is what they've decided to do to try and help matters along. So if none of the foregoing programs are going to be enough to help small businesses or medium-sized businesses get through for the next number of months, so in other words, the expense reduction isn't going to do it. The other option, in broad terms, if you can't decrease expenses, you need to increase revenues. Increasing revenues typically happens one of 2 ways. You up your sales so that you get more money in the door, or you bring in the monies that you have written off previously because your accounts receivable have gone stale, and perhaps your bank has been on the phone to you saying, because you have too many over 90-day receivables, you can no longer include those accounts receivables in your margining calculation for your line of credit with us. I have a client who is in the oil field supply business up in the Grand Prairie area. He is in the business of trucking condensate from wellheads to pipeline collecting points. And his volume of work has been very good, of course, up until about a month ago. He was generating approximately $100,000 a week in accounts to the various companies to which for which he took condensate from wellhead to pipeline. A major customer of his went into CCAA protection in the middle of April and left this particular fellow high and dry to the tune of $1 million. Within 2 days of the announcement by this customer that it had gone under the protection of the Companies Creditors Arrangement Act, my guy's banker had phoned up and said, that used to be a good customer of yours, and they were within payment terms, but we have to now take them out of the margin calculation. So that drops your available credit by X amount of dollars. And guess what? You're bumping right up against the ceiling. So what are we going to do about that? This is obviously a problem that is going to be increasingly out there as more and more companies stretch their payables, and the account creditors are left high and dry, because not only can they not collect the ARs readily, but they're finding their own credit lines hampered by virtue of the recalculated margins. So what did you used to do in the old days, pre-COVID, when faced with an account debtor that wasn't paying debts? Well, you would phone up and yell, you would call your lawyer would write a nasty letter, and if nothing worked, then you would file a statement of claim, serve it, and eventually, if your case was solid, you would end up with a default judgment if the other guy didn't defend, or you would have a summary judgment if your case was so cut, and you would get a judgment, you'd file a writ of enforcement at the personal property registry, and you would commence the usual enforcement mechanism. Well, all of that's been kind of upset by COVID-19. So sometimes you would go to provincial court in the old days because small claims had a jurisdiction for up to $50,000. Small provincial court also dealt with residential tenancies. However, on March the 16th, the provincial court instituted immediate restrictions on court access for all non-emergency matters until May the 22nd. May the 22nd is actually next week. Then on May the 13th, so on Monday, or yesterday, I should say, the provincial court issued a bulletin called the COVID-19 Staged Resumption of Court Operations. And that affects cases that were scheduled to be heard during the period May 25th to July 3rd. That's what they call phase one. So grab the next slide, please. So in that phase one, there are still going to be no in-person appearances for civil matters in provincial court. Anything that was previously scheduled during this period, pre-trial conference, what they call simplified trials, binding judicial dispute resolutions, will proceed by teleconference and video conference. The provincial court will still accept for filing new statements of claim. You can file applications, and they will be triaged by a provincial court representative. Not sure if that's a judge or a clerk. And those which are deemed urgent will be referred to a judge to decide whether or not they will be heard during this time, or whether or not you'll have to wait until phase two, which will be obviously when phase one ends, and we don't know what that's going to mean. So if you have claims or are facing claims within the provincial court jurisdiction, that is up to $50,000, there are still restrictions on what you can do to try and collect the claim. Lucky you if you're an account debtor and you are facing a claim. The delays will give you more time, hopefully, to figure out how to pay the claim off once your creditor can get into court. So that's provincial court. So in Queen's Bench, which is where the bigger claims are heard, there was an announcement, Queen's Bench Master Order 1, which dictated that anything that was scheduled to be heard during the period March 16th to May 31st was automatically adjourned indefinitely. The initial order did not extend it to May 31st, but subsequent orders have amended that period, and we're currently operating under a suspension until May the 31st. During this period, there will be no new matters accepted for hearing, other than what they have classified as emergency or urgent matters. So the way they've defined emergency, you'll see on the screen, is one in which serious consequences to persons or harm to property may arise if the hearing does not proceed. Specific examples of an emergency application, and these are mostly, quite frankly, they're mostly aimed at family law matters, guardianship matters, or end of life matters, for example, if somebody is going to be taken off a ventilator. So there's very few civil law area, commercial law area, that would classify as an emergency. However, there are a fair number that would classify as urgent. Those include urgent or time-sensitive commercial matters where there are immediate and significant financial consequences which may result if there is no judicial hearing. And in that list, in the Master Order Appendix, those include receivership and CCAA applications. CCAA stands for Companies Creditors Arrangement Act. Anton Pillar or Moreva type injunctions. An Anton Pillar order takes its name from a case in Great Britain decades ago, and it's been imported into the common law jurisdictions of Canada. And basically, it's a civil search warrant that can be obtained without notice to the other side. For example, if you discover that your accounts receivable department has been hacked and some fraudster has managed to persuade some of your account debtors to pay their bills into a new bank account, which the account debtor thinks is authorized by you because the hacker has impersonated you. And so they pay large sums of money into an offshore bank account, or better for you if they pay it into a domestic bank account. Once you discover that, and with the appropriate proof, speed is of the essence, obviously, and so the courts recognize that getting a civil search warrant to be able to track that money and getting a Moreva type injunction to freeze that money or to freeze the assets of the debtor if they are about to be dissipated is important. So they fall into the category of urgent. Freezing orders are pretty well just like sale approval and vesting orders are what arise in foreclosures or in receiverships when assets are being sold. Typically, there are deadlines in the accepted offer of purchase that require speedy approval by the court. So these are things that can be brought up to the court, even though all the other things that you would normally take to court are on hold. The process for getting into court is no longer just walk up to the court, file a document, and show up. You have to go through a booking process, again going through a triage judge who will determine whether or not your particular application falls into either the emergency or the urgent category. And if it does, then you will be scheduled and they'll give you deadlines for providing the usual documents. So I guess the bottom line in terms of court access during the COVID-19 period is that access has been restricted. The restrictions will continue until at least the end of this month. They may continue past that. I suppose that's going to depend on how the opening of the Alberta economy and Alberta business plays out over the next 2 weeks, I guess starting today. If things go well, maybe that will be the end of the suspensions and everybody will be back to normal. There will, however, as you can appreciate, be quite a backlog of applications which have been scheduled but couldn't be heard during the suspension. Those will be given scheduling dates once the suspensions are lifted. They will clog up the available court time for sure. If the suspensions continue, then basically all that we will be able to do in terms of going to court for the kinds of things that creditors want by way of normal relief is not going to happen unless you fall into the emergency or the urgent category. So while the period of suspension is happening for court applications, time running under various statutes is a concern. What if you have a limitation period that is going to lapse during the period of time when the courts are suspended? Well, there have been a couple of things happen, and the screen you're now looking at, time suspensions, go back one, please, is what Alberta has done. Under a ministerial order issued on March the 30th, there was a direction that the limitation periods set out in about 100 statutes is going to be basically tolled or suspended from March 17th to June 1st. So that is about 2.5 months. And what that basically means is that if you have a matter that would have otherwise fallen due for a limitation expiry during the period March 17th to June 1, you basically get an extension equivalent to the time period of this March 17 to June 1 period of your limitation period. So there's a number of statutes, the most important ones of which for most matters are the Limitations Act. There are also time limits in the Civil Enforcement Act that have been suspended, the Fraudulent Preferences Act, Part 5 of the Personal Property Security Act, that's the enforcement section. So the kinds of things in which business people are interested, whether they're trying to enforce a claim or resist enforcement of a claim, those are among the statutes where limitation periods have been suspended. The rules of court also have deadlines by which certain things have to be done. In April, an amended master order was issued that suspended all the filing deadlines under the rules of court until May the 31st. There's a couple of exceptions, but the general rule is that if you are under a deadline to file an affidavit of records, take a step, those deadlines have been suspended until May 31st. So that's the Alberta situation. For the perspective in the federal bankruptcy sphere, starting in the last week of April, the superintendent of bankruptcy approached the courts, starting in Ontario, to try to provide some assistance, or some relief, I guess I should say, against certain deadlines that were going to be arising during what they defined as a period of emergency. Their period of emergency is March 13th to June 30th. And it ties into another definition in their orders called suspension period. And what the effect of this master order granted in each province is that certain meeting dates, if they had to take place by virtue of this Bankruptcy and Insolvency Act within the period of emergency, they can now be postponed until after the end of the suspension period. Another consequence of these orders is that debtors who are already operating under the consumer proposal under the Bankruptcy and Insolvency Act, if they defaulted because they couldn't make ends meet, they couldn't honor their proposal, they are relieved from the consequences of default, provided that they have made some payments. And if they've missed as many as 3 payments, you can do that and not be defaulted under the consumer proposal. More than that, you're in trouble. Interestingly enough, there's a notification on the website of the Office of the Superintendent of Bankruptcy indicating that Canada Revenue Agency took the lead in going to the OSB and saying, hey, you know what? If we're the main debtor and we're the main beneficiary of this particular this debtor's consumer proposal, we don't want to be the ones that are responsible for having this guy miss his payment and therefore be in default and therefore liable to be put into bankruptcy. So we won't enforce the payments of our share if we're the lead debtor. Like they say, they're from the government, they're here to help you. Okay, so getting to court is a little bit more complicated now during the COVID-19 period than it was previously. There are still things you can do if you cannot fit into any of the categories of being an emergency or an urgent matter. There were always things that you could do outside of the court system. For example, if you have an existing judgment, there is nothing to stop you from renewing that judgment. There is nothing to stop you from enforcing that judgment. You can give instructions to civil enforcement agencies. They are still operating. They may be having to socially distance from the people whose goods they're seizing, which makes it somewhat awkward if the guy is standing at the front door of his house and let you in, I suppose. And if you are a civil enforcement agency and are being resisted, your normal remedy is to go to court for an order. You can't do that unless you can demonstrate that you fall into an urgent category. But you can issue garnish as a creditor. You can issue garnishee summonses. There's no difficulty with that. There's no court appearance needed for that. The, uh, the clerks are still operating. They're slower, but they are still operating, so you can get a garnishee summons issued. You can also exercise lien rights. Lien rights, to assert them, do not require a court order. You can file a builder's lien at land titles. You can file a garageman's lien at the personal property registry. You can assert a possessory lien. The problem is that you cannot enforce it. You can exercise the right by protecting it. You just can't enforce it without a court order, typically. If you do have the right, for example, under a security agreement, a lease agreement, to seize the asset that is the subject of the lease agreement, and you can do so without a court order, you can go ahead and do that. The third category of things that you can still do without having to worry about a court being available for you, under the BIA, proposal proceedings can be commenced, voluntary bankruptcy assignments can be made without having to go to court. All that is required is a cooperative trustee to fill out the paperwork for you and accept the modest retainer that all of these insolvency professionals require up front. They will then file the documents with the Office of the Superintendent of Bankruptcies for the local receiver, and lo and behold, those proceedings can then begin. And they can continue on up to the point at which some court approval or some court application is necessary. And again, unless you can fit within the urgent or emergency category, you're going to have to wait to go to court for any kind of application that's required under the BIA to the end of. So I now want to cover off a couple of things that are certainly arising, shall we say, as a result of the pandemic. Some of you may have encountered the situation where one of your customers has said to you, I know I promised to deliver you a widget. I can't deliver you a widget, even though I promised to do that, because my widget supplier overseas can't deliver me the widget. And they're blaming this coronavirus thing. So I'm stuck. I can't do it. The contract cannot be performed. So is that a valid excuse? Well, there's a couple of theories that may give your contractual counterparty an excuse for non-performance. Some of the tag names I've put in quotation marks on this screen. The first one is force majeure. That is a contract, a type of a contract clause which has been around for a long time. It basically says, if we encounter a situation that was unforeseen and beyond anybody's control, that operates to relieve the parties from performing their contractual obligations. Like I said, those have been around for a long, long time. There's a couple of things that have to be looked at before you can say that a force majeure clause is going to help you. Firstly, a party who relies on a force majeure clause has to look very carefully at the wording of the clause so as to understand the nature of the obligation that is sought to be avoided and whether or not the COVID-19 pandemic had an actual impact on the non-performance. In other words, you can't simply say everything that I choose not to do under my contract, I can excuse by pointing at the COVID-19 situation. There has to be a nexus between the pandemic and your failure to perform. There are also certain steps you have to take if you are going to allege a force majeure so as to be able to justify it should it end up in court. And this is the kind of thing which I'm going to suggest to you is going to be an increasingly frequent subject of litigation in commercial courts going forward, all over the place. One very high profile example of reliance or attempt to rely on a force majeure clause, which can also be disguised as what they call a material adverse change clause or material adverse event clause, is a case involving Victoria's Secret. For those of you who don't know, Victoria's Secret is a relatively high-profile retailer of ladies' unmentionables. Um, Victoria's Secret case arises because in February of this year, the owner of Victoria's Secret, which was a company called L Brands Inc., signed a deal with a buyout firm called Sycamore. And Sycamore agreed to pay for 55% of Victoria's Secret, the sum of $525 million. That deal was signed on February the 20th. And on February the 19th, the Dow Jones Industrial Average hit its record, all-time record in terms of the size of the Dow Jones. So February was also when people were starting to realize there was something going on overseas that looked like it might turn into something bad. And by mid-month, Victoria's Secret had closed, mid-March, Victoria's Secret had closed all of its stores, and it has closed its online operation. When the deal to sell Victoria's Secret 55% to Sycamore was announced, the shares were more than $23 a share. A month later, March 20th, they traded for less than $10 a share. So if you are Sycamore, you are going to be very concerned about closing that deal. So both parties went scurrying back to the agreement, and they looked for ways to get out. You would typically think that a pandemic would constitute not only a material adverse change, but a force majeure, which would justify the buyer not proceeding with the transaction. However, L Brands had found itself a pretty good law firm, and that law firm had inserted as a carve-out from a force majeure clause the existence of a pandemic. So I'm sure after Sycamore picked itself up off the floor, it went scurrying to look at other clauses in the deal, and it did find that it could probably rely on the closure of the stores as being a material adverse event that excused it from non. So what happened was, in April of this year, Sycamore filed a lawsuit, April the 22nd. Sycamore filed a lawsuit in the Delaware Chancery Court seeking a declaration that it could walk away from the Victoria's Secret deal on the basis that it could terminate the transaction for the material adverse event. That lawsuit was settled on May the 4th. So approximately 2 weeks after it was filed, the parties settled. The nature of the settlement has not been disclosed. However, they did say that neither party was going to pay a termination. So we don't really know whether or not the argument on force majeure carve-out for a pandemic would have succeeded, or whether or not closing stores as a result of a pandemic did constitute a material adverse event, which would excuse performance. But that's not the first, it may have been the first big profile case, but it's not going to be the last. The source, the article that I accessed to get this information is in a publication called the National Law Review, and this is their publication that was put online yesterday. This deal has been written up in the New York Times, or this result has been written up in the New York Times. So it's obviously a high profile enough situation that people are paying attention to. There's a number of other deals, large deals, which have been in the news and may be subject to one of the parties claiming they don't have to perform anymore because of the pandemic. Some of these are, there's a company called Gray Television, which had made an $8.5 billion offer for a company called Tegna. There's a company called Borg Warner, which is an auto parts supplier, which had entered into a $3.3 billion merger deal with Delphi Technologies. Volkswagen, announced that it would be delaying its $2.9 billion bid for Navistar, which is a truck maker. So all of these large commercial transactions have been affected by the COVID-19. Can the party who is raising force majeure or material adverse event succeed in establishing that as a reason for non-performance? Remains to be seen. Anyway, those are the big boys. That's the American commercial world. What about in poor little old Alberta? Next slide, please. There's actually a situation which was reported 3 days ago, in our Court of Queen's bench between Service Credit Union Ltd. And a company called Proform Management Inc. and a number of its related companies. Can the COVID-19 situation be used by a debtor as an excuse to fail to comply with the terms of a forbearance? The Proform companies had attracted the attention of Service as its main credit provider in June of last year. There had been some breaches of the loan agreements whereby Service decided that it wanted to get out of the lending business as far as this company was concerned. Service and Proform entered into a forbearance agreement. Many of you may be familiar with those. That's a typical way in which a lending institution, be it a bank, a credit union, enters into a new agreement with its borrower to try and permit the borrower an opportunity to cure existing defaults, perhaps even find a new lender. It either restores itself to a bankable situation or it finds other kind of arrangements. There's a certain amount of time that's given within which all of that is to happen. Sometimes there's a financial advisor, financial monitor that's appointed to provide insights into what the borrower's problem was, how it got into the situation, report back to the creditor, all of which is with a view towards finding a way to regularize the credit or have it leave. And of course, if neither of those events happens, typically these forbearance agreements call for the execution of certain consent documents that facilitate the credit union or the lender, whoever it may be, enforcing its security with a minimum of fuss. So typically the big picture of the deal is the lender says, we'll give you time to put yourself back into good shape, failing which you have to leave. And in exchange for us giving you time and continuing, presumably, to give you some access to the credit so that you can carry on business during this period of forbearance, in exchange for us giving you time or forbearing from enforcing our remedies, you agree that our security is valid, you owe us the money that our records say you owe us, you've been given opportunity to cure the default, and you're not going to defend, or you're in fact potentially going to consent to a judgment in our favor and potentially to the appointment of a receiver. I think we need that to properly enforce our rights and security. So much of that happened between Service and Proform. A period of forbearance ensued. The forbearance was extended from its initial 6-month term. When the second forbearance expired, there was a de facto forbearance when Service was giving them another opportunity to perform. They still didn't perform. And so eventually Service said, you know what, we've kind of had it. You're not going to be able to get out from under, so we think it's just best that we bring this thing to a conclusion. And since you've already signed consent receivership orders and whatnots, we're just going to go to court. We're going to enter that, and you're going to be in receivership. So the debtor said, no, even though I consented, you can't just enter those orders. We have an opportunity to tell the judge before whom you would have to attend to get this kind of order why it is we don't think that you should be able to enter. And one of the things that the debtor raised in front of Mr. Justice Lemma was the impact of the COVID-19 pandemic. Justice Lemma, who is a very experienced, not an experienced justice on the bench, but very experienced in insolvency matters. Back in his practicing days, he was the lead Department of Justice lawyer for Canada Revenue Agency in Western Canada. So he knows his way around insolvency stuff, having been involved involving the CRA debt in Western Canada the last 10 or 15 years. The borrower said, this is why you should give me a break. The borrower said, companies are seeking an adjournment of the receivership application for the following reasons. A, the companies have been making substantial progress in their refinancing efforts, but the COVID-19 pandemic has temporarily prevented such efforts from being advanced to a conclusion. The majority of the company's customers have either temporarily shut down operations or have delayed their projects pending the resolution of the COVID-19 pandemic. As a result of this, the business operations and employee numbers of the companies are different than they would normally be. Not only did the borrowers try to point to their customers or basically finance companies as being affected by the COVID-19, they went on to elaborate that their search for new financing had also been imperiled by a lack of response by some of the parties that they approached. Justice Lemma looked at all this and he said, you know what, you've been given forbearance since June of last year. You were given an extension of that, you consented to the receiverships. I don't believe that the COVID-19 pandemic is a legitimate excuse. So therefore, I'm going to uphold the consent that you gave, granting the order, and you're in receivership. So what's interesting about this case is that Justice Lemma kind of gives hints by inference as to what kind of arguments based on the COVID-19 pandemic might work. They did not work in this case, but from his comments, you may be able to see what might work in a future case. So his lordship said, in particular, COVID-19's now massive impact was only beginning to emerge in the week of March 9 to 13. I take judicial notice that no provincially ordered restrictions on gatherings were in place that week. It was business as usual at the court through March 13th at least. The Alberta government's COVID-19 case statistics only start as of March 8th. The bar graphs are not calibrated to allow perfect counts, but from a baseline of 0 confirmed cases as of March 8th, the collective number of probable and confirmed cases in those early days appears to be approximately 25 people. That compares to 6,017 cases as of May 7th. Then he says, in any case, the debtor's COVID-19 related evidence is silent or vague about the pandemic having any impact on their business before March 13th. So what the court says implies if you had better evidence as to what the COVID-19 pandemic actually did to your business, in other words, could you draw a direct link between what was happening to your business and the COVID-19 pandemic, maybe you would get a better outcome. But what Justice Lemma said was this evidence is insufficient to show the pandemic having any material impact on the debtor's businesses, refinancing efforts, or asset sale efforts through March 12th, when the second forbearance period ended. So if during the period of forbearance, you're going to say the pandemic made me do this, you'd better actually have some proof, and you better put it in evidence. Justice Lemma goes on to say, this evidence is insufficient, in any case, the debtors received the benefit of a further 19 days of no enforcement between March 12th and March 31st, and a further 5-week stay between March 31 and May 5, almost 2 more months. For all its devastating impact to date, the pandemic did not impair the debtors in any material way through March 12th. Okay, so like I say, no COVID-19 defense arose in favor of this debtor, the profile management. If any of you are businesses in a situation where you can point to a drop-off in business or some other event that is affecting your ability to deal with your secured bank lender in accordance with the terms of your loan agreements, if you can point to the pandemic as being a cause of that, document. Because should it come to the point where your lender says, you know what, we don't want to carry you anymore, it would help you if you could point to these circumstances in an attempt to persuade the bank, lending institution, to give you a more generous period of time within which to get yourself back in line. And that really does underscore one of the main messages of the debtor creditor world. Always keep your lines of communication with your borrowers, with your lenders open. Nothing irks a special loans banker more than people who go radio silent. And at this time, everybody's in the same boat in terms of the effect of the pandemic. It won't come as a surprise if you have to think say, sorry, I wish it were otherwise, but here's my situation. Okay, that is pretty well all that I intended to say in this presentation. If there are any questions stacked up in the chat room, we can start on those.
Various limitations associated with the debtor and guarantee for acknowledgement.
Okay, so give me a minute to flip back to that ministerial order and the schedule of statutes which have been affected by the ministerial order. And lo and behold, the Guarantees Acknowledgement Act is one of the statutes which is scheduled to the ministerial order. So therefore, I would say that yes, the order does suspend whatever limitation period appears in that statute. My recollection is in some of the commentary to this order that the timelines in the Guarantees Acknowledgement Act do not mandate that for example, the material certificate, I guess the acknowledgement certificate, has to be executed contemporaneously with the attendance by the guarantor before the lawyer to have it acknowledged. I could be wrong, but in any event, if there is a time limit linkage, it has been suspended by the ministerial order. Another question? No, that's it? Okay, so do you want to open it up to phone-ins or verbal questions? Okay, so Ashley has unmuted everybody.
Let's do 1:30.
If anybody has a question, just feel free to speak up.
Yeah.
Well, okay, if there are no questions, I certainly don't pretend to have covered
you know, we're going to do the cremation.
COVID-19 impact on creditor-debtor situations with the depth that they deserve. So if any of you have a question, would like to pose it, the screen that Ashley is now showing has my direct line at work and my email contact. Like most people, I am
780
my office. I'm primarily
729
unless I come into the office
7785.
special occasions such as this. But if you call my office line, I do monitor that for messages, and I will pick it up and I will call you back. Like I said, in the absence of a phone message, I respond to email. Eventually. So that's it. Thank you again for taking time.
And two of us can come in.
This presentation.
Okay, wonderful.